Welcome to Law Made Simple with John Wekesa, the All Seasons lawyer, for best legal tips.
Good morning, good afternoon, good evening from wherever you're following us. My name is Wekesa John, the All Seasons lawyer, and today I want us to talk about court process. And we shall be focusing mainly on the commonly asked questions when it comes to the court process. The number one question is, how do I file a case in a court? Now, when you decide to file a case in a court, the first thing that you have to begin with is to prepare the document that you'll be presenting before that particular court. And these documents are what sets out or explains your problem to the court. If you have a lawyer at this level, it will be very important for them to chip in because they can be best placed to help in preparing the documents. And those documents usually vary. They may include, for instance, starting with a plaint, a petition, an application, or any other document depending on the nature of the case that you are presenting before this particular court. You then go to the court registry. At that registry, you will pay the court filing fees, and the court will assign you a case number for your case. You'll also be issued with summons, and these summons are supposed to be served together with the other documents upon the other party to enable them prepare for court. So from there, the case will begin, and you will have other events to follow, such as mentions, hearings, and finally, of course, you'll have a ruling or a judgment. And at this level, one important thing that you need to take note of is that you need to preserve the receipt that you have been issued with when you file the case, because it may be required at any level when the case is progressing or even after the case. You also need to master the case number or to write it somewhere, because that is what you'll use to track the progress of your case, and so it is an important aspect of the case. Another commonly asked question is, what are pleadings in a case? Pleadings are the official court documents that outline each side's story, and they may include, for example, a plaint which may be filed by the plaintiff and a defense which may be filed by the defendant. Other documents may also be filed in a case, and for instance, you may have a reply to defense, a counterclaim, and a defense to the counterclaim. And the list can even extend further depending on the nature of the case that has been filed before this particular court. These pleadings are what show each side's story, and they form part of the foundation of the entire case that the court will be, of course, building upon when the case progresses to the hearing and finally to the judgment. In short, what we are saying is that our pleadings are a written story of each side. Each side has presented its story, and when both of them are put together, that is what now we are calling pleadings. Another commonly asked question is, what happens during a court mention? An important thing to note is that a mention is not a hearing. A mention is usually more or less like a check-in, and a judge or a magistrate may ask questions during such a session. For instance, the judge or the magistrate may want to know whether everyone is ready, or whether documents have been filed by all the parties in the case, or whether any party has been left out or has not been served with summons. Those are some of the key issues that usually have to be handled during the mention, and mentions are usually short. They are usually very brief, and they may last for just a few minutes. In short, a mention is just a session to confirm the status of the case, or rather when you have to do a status update for where the case has reached. Another commonly asked question is, what is the difference between a ruling and a judgment? And this usually confuses a lot of people. Now, when you hear of a ruling, you need to know that this is a decision on a temporary issue. It may be a decision on a procedural aspect of a case. For instance, it may be an injunction, a stay order, or even a ruling on a preliminary objection. All of those, if they come in a case Now they have to be decided on what we are calling a ruling. But when you hear of a judgment is usually the final decision of a court after hearing a full case. In short, to put it in other words, a ruling is a temporary decision and a judgment is a final decision. Another commonly asked question is, how do I enforce a court order? Now, once you obtain a court order, you must enforce it. You have to enforce it, or otherwise it will just be a piece of paper which won't, of course, be of any help to you. So in enforcing a court order, you have to go to the court registry and apply for execution. Now, when it comes to execution, this could include a number of things. It may include warrants of attachment through an auctioneer. It may also include warrants of arrest. It may other times include a garnishi order, where you have to seize money that is in a person's bank account. It may also include an eviction order when it comes to land cases. So when you have to execute, you need to visit the registry and make sure that you obtain any of these documents so that you are in a good position to proceed with the execution. Another commonly asked question is, what happens when a case is dismissed? Now, if a case is dismissed, it means the court has refused on a foundation that it has been found without merit. And there is a number of reasons that may make a case to be dismissed. Number one reason may be insufficient evidence. Another reason may be a mistake that is procedural. For instance, the plaintiff has made a procedural mistake and has failed to do certain crucial things. Another reason could be failure to appear before a court of law. So if you are required to appear before a court of law and you fail, for instance, you have missed to attend a hearing and it is your case, that could be a proper ground for case to be dismissed. Now, when a case has been dismissed, you have a number of remedies that you can use when you have found yourself in such a situation. You can, for instance, appeal to a higher court. If it was in a magistrate's court, you can appeal the decision to the high court. If it was in a high court, you can of course appeal to the court of appeal. That is the number one option that you can have in such a situation. Another option that you may have is to file an application to reopen the case. So if you file an application to reopen the case, of course you have to give proper reasons for that, and the court will consider and see whether there is merit in what you're saying. Another option that you may have at this time is to refile the case afresh, because the case has not been determined on merit. It is still open, and you can actually file that case again and have it progress to the conclusion. So the other commonly asked questions, or rather the other most commonly asked question is, what is an injunction and when can I be granted one? Now, when it comes to this issue of an injunction, you need to know that an injunction is a court order that, to put it more precisely, is a court order that says stop whatever was going on or stop whatever you were planning to do. And this is an order that prevents someone from doing something, for instance, selling land, demolishing a house, or even damaging property. And that person has to stop that action until the case is heard and determined. Now, when injunctions are granted, these are orders that are usually granted when there is an urgency. And they may also be granted when your rights are at a threat and waiting for a judgment will cause a great harm. So that means that they have to at least be granted at this level, so that when the case is heard and determined, whatever harm you will have suffered will have been prevented, and you will be safe by then. You can think of it, in other words, like an emergency brake. Emergency brakes in a motor vehicle, they can be what we can equate to now what we are calling injunctions in a court process. Another commonly asked question is, how do I appeal a court decision? Now, when you are dissatisfied with a court decision, that means you believe that the judge made a mistake and you want to get a second opinion. Then you will have to appeal, and the appeal will have to go to a higher court. Usually, you have to first start by filing a notice of appeal within 14 or 30 days, and that will depend on the court from which you are appealing. And then you will have to prepare a record of appeal, which will include all the documents that were filed and were used at the lower court when the trial was happening. The higher court will, of course, have an opportunity to go through and review all the documents that you have presented before them, and they will have to make their own decision on the issues that were in that case afresh. So that is when it comes to an appeal. And the most important thing to note at this level is that timelines are very crucial when it comes to appeals. So if you are supposed to appeal within 14 days and you've not complied with that, or you are supposed to appeal within 30 days and you've also failed to comply with that, then your appeal will be struck out on grounds that you've failed to comply with the statutory timelines. So those are some of the commonly asked questions when it comes to the court process. The list is a bit longer, and that means we'll have to do a second part to this video